time, we will present issue 1, a proposed constitutional amendment regarding the rights of crime victims. We would like to welcome Ms. Catherine Harper Lee, Executive Director of the Ohio Crime Victim Justice Center, to present in favor of this amendment.
Good evening, and thank you so much for your time. I am the Executive Director of the Ohio Crime Victim Justice Center. That is a nonprofit organization that I founded 17 years ago with the sole purpose of protecting and enforcing crime victims' rights throughout Ohio. It is the only organization in the state of Ohio where crime victims can report and receive assistance, free legal assistance, to protect their rights. Over the past 17 years, the majority of victims' rights complaints we get involve women and children who are victims of sexual violence or domestic violence. I support Marsy's law, State Issue 1, because this constitutional amendment is desperately needed to ensure that crime victims' rights are enforced and that they're no longer ignored. Real brief history. 24 years ago, a victims' rights constitutional amendment was passed here in Ohio by nearly 78% of the voters. The intention of passing that was to provide crime victims with reasonable and appropriate notice, information, access, protection, and to a meaningful role in the criminal justice process. Unfortunately, what we've seen over the past 24 years is the current Constitution does not provide the protections that were intended. We did not anticipate that victims' rights would be simply ignored. And the current constitutional amendment has no teeth. There is no clearly articulated enforcement mechanism, so it doesn't provide victims the opportunity to enforce those rights when they are ignored. So as a result, crime victims' rights enforcement is sporadic. Some county officials will enforce victims' rights while others will simply ignore it. And I want to provide a couple examples because I think this will help you better understand. We recently represented a woman who was abducted and raped. It was a very good case for prosecution. The woman had significant injuries, DNA evidence, and in this case, and one thing that it's important to know, that crime victims currently have the right to object to substantial delay. The other thing that's important to understand is that most criminal cases, felony cases, will last anywhere between 12 to 18 months. It's typical. This woman's case had drug out for over 5 years. And I'll tell you something else. Where we see victims' rights cases getting that delayed like that is primarily child sexual assault cases. And I'll tell you what, it does tremendous damage to children and their families when their cases get delayed that long. And there's absolutely no reason for it. The delay caused this woman and her family significant emotional and financial harm. When she attempted to protect her right by filing a motion to object to the delay, the judge ignored her motion. Not only did the judge ignore her motion, in my opinion, she penalized the victim for attempting to protect her rights, because rather than continuing the case now every 2 to 3 months, the judge continued the case for 8 months, 8 months more. 8 months came, we thought, okay, there's no way the judge is going to grant another continuance, and the judge granted another continuance. We filed a second motion on behalf of the victim to protect her right to delay, and the judge sent another message. This time she continued the case for 10 months. And the judge declared that victims don't have standing meaning the ability to enforce their rights, so therefore she was not even going to consider the victim's motion. State Issue 1, Marsy's law, will provide teeth. It will provide that enforcement mechanism that victims so desperately need in order to protect their rights. Some have said that Marsy's law would bring the criminal justice system to a halt, that if victims have the ability to actually protect their rights and file motions, everything would slow down. That's just simply not the case. Many states have strong enforceable rights for crime victims. Arizona, California, Illinois, actually 13 states have strong enforceable rights in this country, and it did not cause any delay whatsoever. As a matter of fact, when their constitutional amendments were passed with enforceable rights, the system perked up, paid attention, and responded correctly and allowed victims to enforce their rights. The other is, sorry about this, I had notes coming in here. Also, Marsy's law will protect crime victims from unnecessary invasions of privacy. I'm going to give you another quick example. We also just recently represented a woman who two men broke into their home on New Year's Eve to rob them. She witnessed her significant other and two children murdered in front of her. They attempted to kill her by shooting her in the head and stabbing her in the face. And miraculously, she survived. There was one issue though. She didn't. Okay, I'm going to have to not explain that. I apologize, I would like to. But Marsy's law protects unnecessary invasions of privacy for crime victims by ensuring that the courts follow the proper procedures if they think that they need information from a victim, and that's to subpoena a victim and allow a victim to have a hearing before they're forced to turn over private information. It's not to deny defendants access to information for their case, it's just to say that that has to be weighed and balanced. Also, amending our Constitution is said is a serious matter, and yes, we agree. It is absolutely a serious matter. But the reality is, crime victims must have enforceable rights if we are going to truly have a criminal justice system that's fair and balanced. And I will say right now that we have over 300 state and government officials that support State Issue 1 and Marsy's law, including Hamilton County Prosecutor Joe Dieters, and Ohio Attorney General Mike DeWine is also co-chairman. Thank you very much.
At this time, we'll have Ms. Nicole Plum, Ohio Public Defender's Legislative Liaison, is here to present an opposition.
Thank you, and good evening. I'm Nikki Klum. I'm the Legislative Liaison for the Ohio Public Defender. I appreciate the invitation to this event and the opportunity to speak in opposition of Issue 1. To be clear, the Ohio Public Defender opposes Issue 1 not because we are opposed to victims having rights, but because Issue 1 will cause more delay, more litigation, and more confusion in the criminal justice system. Instead of solving problems, Issue 1 will actually create new ones for victims. Before I get into detail about why OPD does not support Issue 1, I also want to note that the Ohio State Bar Association and the Ohio Prosecuting Attorneys Association have also voiced opposition to the issue. One fact that must be acknowledged is that Ohio law currently contains numerous protections for victims. Outside on the table, you'll find plain folders like this that I've brought, and in those folders you will find Ohio Revised Code Section 2930. And the reason that I brought this for you and have it available for you to thumb through is just so that you can see the pages and pages of extensive and detailed rights that Ohio provides victims. Now, as you just heard, proponents of Issue 1 argue that these rights are not being enforced. If that is the case and victims' rights are not being respected, then the remedy should be ensuring that resources are available to prosecutors and law enforcement so they can comply with their current obligations. As a former prosecutor myself, it is my experience that failure to comply with the law is not because prosecutors and law enforcement have a callous disregard for victims' rights. It is a lack of resources that causes victims to fall through the cracks. And the only way to ensure that that doesn't happen is to guarantee that adequate resources are in place. But Issue 1 will not stop victims from falling through the cracks because Issue 1 does not identify funds and it does not mandate that adequate resources will be allocated for victims. Now, there may be occasions in Ohio when prosecutors and law enforcement are brazenly just disregarding all of the laws in 2930. In those instances, those people should be held accountable for violating the law. However, those people will not be held accountable under Issue 1. In fact, the language explicitly bars victims from doing that. Without adequate resources and the ability to hold prosecutors and law enforcement accountable, Issue 1 is just words on paper. And those words have no ability to actually help and protect victims. Issue 1 includes language that does provide victims an ability to petition the Court of Appeals when they feel their rights are being infringed. This is the teeth that the proponents were speaking about earlier. The problem is that Issue 1 doesn't specify if victims get a free attorney, like defendants get a public defender. The obvious question is, how is the right to petition the Court of Appeals effective if they don't have an attorney to help them? Without a free attorney, they either have to pay out of their own pocket for one, or they have to spend their own time and energy figuring out how to petition the Court of Appeals. Although issue 1 is unclear about this, it seems that the intent would be that they get a free attorney, or else this right is basically meaningless. But free attorneys are not free. They must be paid, and providing all victims, from the victim of a rape case to a victim who's had $5 stolen, with a free attorney is a significant cost and burden to local governments. Instead of making this right to petition the Court of Appeals a constitutional amendment, wouldn't public money be better spent enforcing and protecting the rights that victims already have under existing law? Isn't it better to use that money to make sure that victims' rights are never violated up front so that they do not need this additional right of the ability to petition the Court of Appeals? On top of the extra cost, the petitioning Court of Appeals, whenever a victim feels that their rights have been violated, will actually create more litigation and prolong criminal cases. The case will ultimately be stayed while the petition is being heard in the Court of Appeals. So instead of stopping delays, which we've heard is the goal of this amendment, it will actually create new delays. Inside the folders out in the front, there are also copies of, I'm going to speed through really quick, there's also copies of the Ohio Bill of Rights and the proposed language of issue 1. And in that, you'll see that this would be the largest section in the Bill of Rights, even larger than the rights guaranteed to those of accused. And additionally, in that language, nowhere does it state that if a victim wants to not provide information requested by a defendant, that they get a hearing. It just states that they get to refuse to provide that information. And that could be things they have in social media accounts that might help a defendant establish an alibi or the identity of the true perpetrator, which could lead to people wrongfully going to prison who haven't committed these crimes because they couldn't get the evidence that they needed. Victims are not protected when the wrong person is in prison. So we ask that you consider this and oppose issue 1. Thank you.
What questions do we have at this time for Ms. Harper Lee or Ms. Plum? We will alternate pro and con questions. Please address who you're asking the question to.
Hi, I have a question for Ms. Klum. You mentioned that issue 1, it would bar victims from holding the violators accountable. How does it do that?
I'm sorry if I said that. I think I might have misspoken. I guess, in what context?
Sorry, I thought that you had mentioned that issue 1, the language of issue 1 would actually prevent the victims from holding violators of their rights accountable.
Oh, yes, okay. Sorry, I misunderstood the question. Yes, actually, like I mentioned, the language of the proposal is in the folder, and if you look at section C of that, it states that this doesn't specifically create a cause of action for damages or compensation against the state, any political subject, blah, 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 blah. Basically, what that's saying is that if a prosecutor or law enforcement officer is just ignoring a victim's right, they're not letting them participate, the victim then can't turn around and sue the prosecutor or sue the law enforcement agency. So they don't have an enforcement mechanism if their rights are being violated. So without an enforcement mechanism, what good is a right if you can't actually enforce it? And this language explicitly prohibits that.
Am I able to also answer the question? Is that fun?
I don't make the rules.
Okay, if that's okay, if I may also address this. That current language, that language is in the current Constitution, and it's also in every other Constitution throughout the country. Crime victims are not seeking to sue law enforcement or to sue prosecutors or courts when their rights are violated, nor would you find it in the Constitution, elsewhere in the Constitution, that they would necessarily have that ability to do so. Crime victims are merely wanting the opportunity to be able to enforce their rights. So currently, right now, we have a system where judges are saying victims don't have standing to enforce their rights. But Marsy's law does provide the teeth, and it does clearly articulate that victims will have the ability to petition the court when their rights are violated. This means that the judge that I gave the example of, that ignored the victim's motion when she objected to the delay, could no longer ignore that motion. The judges will rule on the motion, and how it's worked in the other states that have enforceable rights is that the system did operate smoothly, victims' rights were enforced. Elevating victims' rights to the level of the Constitution gives them more meaning and more weight when courts are determining and balancing the rights of the defendants and the rights of the accused. And it is not slowing down the system whatsoever. You might have a little speed bump at the beginning, right, when they're like, victims are first filing motions. Once the courts make their decisions and those decisions come out, the rest of the system falls into place more smoothly. Thank you.
So, I don't know if I'm reading this correctly, but is there kind of an end line for when a victim's right to petition ends? So the way this is written, it looks like the victim has the right to petition the court to protect the victim's rights. So does that mean that after the judge or jury has come out with a verdict of not guilty, the victim can?
No, it does not give a victim the ability to overturn a conviction, not at all. And as opposition has stated, there are many rights for victims in the statute now. 2930 is loaded with rights, and there are other rights of crime victims strewn throughout the Ohio Rights Code. The problem now is that those rights are being ignored. And without the ability to enforce that issue 1, Marsy's law will provide, they will continue to be ignored. But no, it does not. A victim cannot overturn a conviction. And you'll see that those rights are enumerated. If you look at 2930, they're clear. And they're basic fundamental rights. The rights to be notified of a hearing, the right to attend a hearing, the right to attend a trial, the right to protection of private information that is not relevant to the case. And again, crime victims are not, and no one is preventing defense from going after information that is relevant to their case, not at all. It's just that they cannot, they have to follow the rules, like the Rule 17 subpoena, to issue a subpoena to the victim, and then to show cause that they need the information. It's not preventing anyone, defendants from getting that information. And so there are very clear articulated rights, and it just will provide victims the opportunity now to enforce those rights because they've not been able to do so for the past 24 years.
I would respectfully disagree with that, actually. I think that the proponent is correct that words do have meaning, and actually in other states that have enacted Marsy's law, some of them explicitly say that the victim's right, the victim's ability to enforce their rights don't undo guilty verdicts or don't undo plea deals. We actually don't have that language in this. So that's another area where litigation is going to have to sort that out. Do victims have that right? We don't know. This is silent on that fact. So that's actually going to be further litigation, further delay while we get those things figured out, because Ohio chose to be silent on that when other states did not. But the other thing that has meaning is this word petition. And in a legal context, a petition means an extraordinary remedy. It means a writ to the Court of Appeals. And a writ to the Court of Appeals also comes with an appeal to right to the Supreme Court. So what I mean by that is if a victim feels that their rights are being infringed and they do a writ to the Court of Appeals, whether it's the state, the defendant, or the victim, because I guess there's now 3 parties to this litigation, whoever doesn't prevail has an appeal of right to the Supreme Court. So now we've interjected yet another area of litigation, another area of delay in a criminal case. So instead of accomplishing these goals of stopping delay and enforcing victims' rights, we've actually complicated the situation more and created further delay.
And once those cases are heard, and once those cases are taken up to the Supreme Court, and the Supreme Court makes a decision, then that will be the rule. That will be the lay of the land, and there will be no longer delay. But we can't live in a society where we say that victims have no ability to enforce their rights, or we don't want to allow victims the opportunity to enforce their rights simply because there might be a momentary delay while the courts render their decision and case law is established. Once case law is established, then there'll be no additional delay, and if there's delay, it will be minimal. But the fact is, crime victims require and deserve to have their rights protected and enforced if we're going to truly have a criminal justice process that's fair and balanced.
And I would respectfully disagree that those petitions up to the Supreme Court would cause case law, because actually the Supreme Court would be answering the specific question in that case, and it would be very fact specific to what's happening to that victim or that defendant in that case. So actually we're going to see a lot of litigation up to the Supreme Court. And I agree that victims should be able to enforce their rights, and that's the problem that we have with this, is that there is no enforcement mechanism within this. It does nothing more than what's already exists in 2930. And so if those rights are not being respected and enforced, then we actually need to focus on the issue and make sure that those rights are being protected and enforced, instead of amending our Constitution in this profoundly restructuring way.
And I will add last to this, that prosecutors and courts have known for 24 years that crime victims have had statutory rights, and they have been repeatedly ignored. And the only way to provide that equal protection is to elevate it to the level of the Constitution and provide the enforcement mechanisms that will establish case law, case precedent, because mind you, victims don't want to sue the state. They just want their voices heard. They want their rights protected.
Do you have any more questions? Have 1 minute.
What other states have passed this law, and what kind of track record as far as more or less cases and the cost?
You know, we're finding out that there's no money for enforcement or resources in this Marsy's law, and Ms. Plum says that we need to have more resources at the state level. So what kind of track record have we seen in other states, and how many other states have passed this, and what kind of track record?
Currently, it's been currently it's been enacted in Montana, South Dakota, North Dakota, Illinois, and California. And each of the way Marsy's law is written in those states is slightly different, so it's not a comparison of apples to apples. But I will say in Montana right now, the law is stayed because the ACLU filed suit and an injunction was granted, so it's not happening right there. But in California, where their law was very specific that victims don't get free attorneys, and it's an attorney that they have to pay for, again, with this inability to enforce within our version of Marsy's law, they have actually found that disadvantages low-income victims because they can't afford attorneys. So again, they have these rights that are written out, but they're meaningless because they can't be enforced because these people can't afford attorneys. Well, in this case, if we're going to give them a free attorney, that's great. Maybe now they have a bit more of an enforcement mechanism, however limited with this petition language. But now we have all this cost on the local governments.
And what's happening in other states, and Arizona, by the way, has had enforceable rights for crime victims for over 20 years. And that is working smoothly. And they have nonprofit organizations that provide free legal assistance to crime victims. Universities provide free legal assistance to crime victims to protect their rights. So when we talk about the underserved, it's going to work similar to legal aid societies. And that's what's happening in other states, that victims who don't have the means to hire attorneys to enforce their rights are seeking it out that way. And as far as this causing an unnecessary burden to the counties, as far as notification, counties already have notification processes in place to notify. The cost is not going to be, and nor has any other state found any significant cost increase when it comes to protecting crime victims' rights. It's more of a reallocation of resources. And again, they've not seen significant cost increases, and the end result is victims' rights are being honored in those states.
Actually, local governments have seen cost increases. You can do a quick Google.
Okay.
Thank you, Ms. Harper Lee and Ms.